Is your farm trust revocable or irrevocable? What is the difference? Why does it matter? Watch this video to learn more. Hi, I'm Jason Wagner, the farm lawyer. I work with family farmers every single day to help them pass the farm on to the next generation. Today we're talking about one of those fundamentals is, what is my trust? Why do we use trust? Is it revocable or irrevocable? And why does it matter? So right off the bat, I've had some other videos where I talk about why you see trusts in the plat book. Why are they popular? A lot of the videos I talk about farm estate planning, and a trust can be one of the central components of that. Why? I mean, you're not going to die with nothing, or you may be in the midst of a transition. It's going to take time. We don't want things to fall through the cracks. We need to plan. So this trust oftentimes will take the place of traditionally what would have been in a will. Well, why don't we use the will? Why do we use a trust instead? Don't they get to the same endpoint? Well, yes and no. First off is Minnesota's estate tax exemption is low compared to what the average farm size is and what the value of average farms are in Minnesota. It's a $3 million exemption. We can get another $2 million of family farmland deduction, as I talk about in the guide to the family farmland deduction video. But we don't get to automatically share that with our spouse. So the average size farm in Minnesota is going to be over that $3 million, which means either getting that family farmland deduction or being able to use our spouse's exemption becomes very, very important, or both in a lot of cases. But without having a proper estate plan that is designed to allow us to use both spouses' exemption, we're going to be stuck with one. It's not an automatic. You can't fix it after the fact. We have to have the estate plan set up properly in order to do this. So that's why we have trusts. They allow us to keep some assets in the deceased spouse's name in order for us to qualify those assets for estate tax exemption and protection. Another reason, trusts are going to avoid probate if they're funded properly and used properly. Probate is a public court process of proving up a will. Some people think, well, I have a will. Doesn't that mean that I will not be subject to probate? No, that is not at all what it means. A will is instructions for probate. It says, I'm ready for probate now. Here are the instructions, which is, good in the sense that it allows us to avoid the unknowns. We know what you want out of this probate, but it doesn't avoid probate in any respect. We also have to think about, do we want everything to be public? Do we want this to be a public affair? That potentially gives people that want to complain a platform to complain. Can they complain if they don't like the trust? Sure, they can, but they would have to initiate a court process versus having one handed to them where they can go and voice their concerns. Another reason is maybe there are things inside of your farm estate plan that you don't want to be public. You don't want your neighbors or your cousins or other people to know this is how the estate is set up. And if you put that will into probate, your instructions of what you want to happen when you die, it is public record now and forever. Anyone can access it, in Minnesota at least, with an internet connection. There's no special login, there's no subscription, there's no cost to it. It's all available. I can search it up. I can find your will today if you have filed a Minnesota probate. So trusts are a popular device that us farm estate planning attorneys like to use for all of those reasons. But are we talking about a revocable trust or an irrevocable trust? Virtually all of the farm estate plan trusts that you're going to see in the plat book or when you meet with your attorney are revocable. They're a living trust. It's a revocable trust. That means that you can change it, you can amend it, you can take things out of it, you can add things to it, as much as you want during your lifetime, as long as you're of sound mind and have capacity. And it's not going to have any tax characteristics attached to it. You still own the property. The trust still has your social security number. It follows you around. You haven't created a new entity that files its own tax return. The trust is like a alter ego to yourself. And that's important because the whole point is that we want to be able to change this. We want to be able to amend it and update it over time. We want you to review this every 3 to 5 years and make sure that it still reflects your wishes. But what about irrevocable trusts? Well, a revocable trust becomes an irrevocable trust at some point in its lifetime. Typically, that's going to be when the grantor, the person that established the trust, dies. It might also become irrevocable upon incapacity. You can no longer amend the trust, so is there a reason for us to keep it still amendable and revocable? But what makes a trust a revocable trust? Is it in the name? Does it have to say Farmer John's Revocable Trust and that's it? No. In fact, it's usually the opposite. A revocable trust is revocable by its terms, okay? Most of the states in the U.S. are governed by the Uniform Trust Code. Here in Minnesota, we have the Revised Uniform Trust Code. It's very clear. A trust is revocable because it says it's revocable, not because of what the title of the trust is. Anyone that's looking at a trust and determining is this a revocable and irrevocable trust must look at the actual language in the trust. You can't just take the title of the trust. That's a good shorthand or a shortcut way to give you a clue if it's revocable or irrevocable, but it is in no way going to be the end-all be-all. We have to look at the document itself to know if this is revocable. So you might see the trust called a revocable trust. You might see it called a revocable living trust or just a living trust. You might see it called the trust agreement of Farmer John. Notice there's no revocable there. Or you might just see it called the inter vivos trust of Farmer John. Inter vivos means it was established during life. So again, it's a living trust, but you notice the word revocable is not in the title. Or simply you might see it as the Farmer John Trust. Okay. Any one of those are commonplace. It can vary between firms and geographic regions, and it even changes over time. You see the older trusts might have a different name than some of the newer trusts. But importantly, you can still have a trust called the Farmer John Revocable Trust, and it is not a revocable trust. Why? Because again, what if that trust isn't revocable by its own terms? It doesn't meet the trust code definition of a revocable trust. It has to be revocable inside of the trust document. Or what if that trust has become irrevocable by its own terms? Maybe the person died. Maybe they're incapacitated. Well, that doesn't automatically change the name of the trust. Through the course of administration, we will change the name of the trust, but the trust itself is still going to say Farmer John Revocable Trust, even though it is no longer revocable. So, in other words, the trust name can very well be Farmer John Revocable Trust, yet the trust is not revocable. The trust can be irrevocable. So for that reason, you cannot take the shorthand name of the trust and assume you know whether it's revocable or irrevocable. You need to look at the actual document and the terms inside of the trust so we know if this is a revocable or an irrevocable trust. Or if it was a revocable trust, is it still a revocable trust? Okay, it's very important. Occasionally we work with banks or financial institutions or co-ops, and occasionally we need to help them and show them this is what the trust says, this is what it means. Very common when we're doing land sales or house sales is it's in the trust. Whose social security number do we use? We use the grantor's social security number. It's going to get reported to the grantor for tax purposes, meaning their personal tax return. Okay. The trust itself is disregarded for tax purposes until it becomes an irrevocable trust and has its own tax filing requirement and tax ID number. So remember, if you're doing farm estate planning and you have a trust, is it revocable or irrevocable? Unless you had a very long, detailed conversation with your attorney about establishing an irrevocable trust, and that irrevocable trust has its own tax return, you more than likely have a revocable trust. But there's a really quick and easy way to tell. The name will give you a clue, but most importantly, you need to look at that trust. Does it have language in it that says it's revocable? If it doesn't, by definition, it's irrevocable. But likewise, if the name says it's revocable, but the trust is not revocable by its own terms, it's not a revocable trust. We can't just rely on the name of the trust, and putting the words revocable into the trust does not magically create a revocable trust if it's not properly drafted as a revocable trust. If you'd like to learn more about farm estate planning, including trusts and other tools that we use to help farmers pass the farm on to the next generation, check out my YouTube channel, subscribe, follow, and go to farmlawyer.com.